Vic, what's the last name on this gentleman?
Wilkins, age 21.
Oh, you're Christopher Wilkins.
Yes, sir.
Wilkins, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On May 20th, 2024, officers were dispatched to the address of defendant's stepfather. The complainant was stated he confronted his son about missing items. The complainant was told the defendant to get ready for rehab. The complainant was noticed his jazz bass guitar was missing and observed his neighbor's cameras, which showed his son to leave the house. The total value of that guitar was $480. That was all I have on this one, Your Honor.
Sure, we know he did it?
Your Honor, it stated that there was...
So dad is saying there are several items missing from the house.
Yes, Your Honor, including a guitar.
Guitar?
Bass guitar.
Anything else?
Yes.
Does dad call the cops on his own son?
No, Your Honor, it was...
Stop.
My fault.
Stop. Don't
Fuck.
say a word. Are you losing? So why talk?
I'm not sure how the police were contacted here, Your Honor. It just says that they met and spoke with the complainant.
Another report written like it's just going through a drive-through.
So, Your Honor, the only thing I would say is, she's facing this. The defendant had initially declined any of the allegations, but later told his mother that one of the items that was stolen, which was a bicycle, was later stolen from the defendant when he left it at his store.
But here he's charged with a bass guitar. What the? I have a pet lizard named George. Really? Mr. Wilkins, I'm going to find there's no probable cause to go forward in your case. This life is a very short life. And when you start racking up convictions, it really hoses you. It's really hard enough as it is as a black man in today's society. And when you start racking up convictions, especially theft convictions where you're branded a thief, do you think it helps? No, it doesn't. Get into school, get some knowledge, get a degree, find something to do, and make a lot of money. That's what life's about. Not ending up in court with a theft charge. You know what I mean? If you have a drug problem, address it before it becomes a real issue and it takes a hold and grabs you by the boo-boo. You know what I mean? Plenty of people in there. We don't need any more. Please. What happened with upstairs?
We're gonna go on a 15 months defer down here, and it's gonna get resolved.
Are you going to dismiss that one in exchange for this one?
And
And the weed? Got it. Okay. You know, there's not many times that you're going to be afforded this kind of deal where they're going to dismiss a felony in exchange for a plea on a misdemeanor. So I would be very, very careful. If all this stems from self-control or usage of dope or alcohol, I mean, really, there's some people when they drink, they become the life of the party. They're happy, they're fun to be with, they crack jokes. And then there's some people that turn into the devil incarnate. If that's you, then this should be a wake-up call. If it's not, what's it gonna take, 25? You're charged with two very serious offenses. You have the assault down here, you've got the assault upstairs. They're going to dismiss that felony assault in exchange for this one. You're entering into a very serious probation where it's a 15-month deferred. This is a type of agreement where if you complete it successfully, you do not end up with a conviction on your record, but it's not dismissed. If you complete it, there's no conviction, but you can't tell people it was dismissed. It's not dismissed, just you complete it successfully, you don't end up with a conviction on your record. You need to understand that there's still an affirmative finding of family violence. You pick up another one of these, you're looking at a third-degree felony, another 2 to 10 at the penitentiary. Do you understand? You can also never own a gun or ammunition as a result of this plea bargain agreement as well. Do you understand? Is this what you want to do? You give up nearly every right known to man by entering into this agreement saying, look, I'm going to make it, and if I don't, you can put me in jail for an entire year. That's the agreement that you're entering into now. So for you to complete this successfully, you must do a batter's intervention prevention program. This is a tough one. This is a class that you have to attend once a week for 18 weeks. If you miss it, they're going to kick you out of the program. If you get kicked out, we issue a warrant for your arrest. We'll have a hearing here to see if you violated. No drugs, no alcohol. You will be tested like crazy to ensure that you're not using. You must also do a TRAS. This is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill them as well. 20 hours of community service, $100 one-time donation to the family violence provider, no threatening or harassing abusive contact with Mr. Cockrell. Do you have children? I think that in lieu of community service, I would like to do a parenting class. And if she does a parenting class, then I'll waive the community service. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you're stuck with this until you complete it successfully or it gets revoked. Do you understand? I like to reward people. I like to encourage people to do well. And what I normally do is, if you do well in this agreement, if you don't test positive for dope or alcohol, you get all your classes done and you're nice to everybody, I'll take you off in half the time.
Okay.
So you can be done in half the time. Just be nice. Don't pick up any new cases and don't use. You understand? Is this what you want to do? How do you plead to the offense of assault of a family member? Guilty or not guilty? I'm not going to find you guilty now, Miss Loyola. I'm going to wait essentially for 15 months to see if you're able to comply with this. As part of this agreement, the possession of marijuana will be dismissed and your other case upstairs will also be dismissed as well. Do you get child support for the children or? Okay, cut her fees. It's never about the money. I don't care about the money. I care about you doing what you say you're going to do and showing up and doing it on time. The worst possible thing you can do is either pick up a new case or abscond. You just take off. That's an instant warrant in this case. You understand? So if you ever have any problems, come back. We can always work through it. We can talk about it, but just doing nothing and taking off, it's the worst thing that can possibly happen. All right, so I'll follow the agreement, send it to everything. Good luck to you, ma'am. Good morning, Ms. Blewett. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, officers were dispatched to an assault in progress call. The officer met with complaining witness one, who stated that he, the defendant, and the other complaining witness were in a polyamorous relationship. The first complaining witness stated that the defendant had sent numerous texts and calls and showed up unannounced at the residence. The first complaining witness stated the defendant struck him in the face while the defendant had a phone causing pain and a tooth to become loose. The second complaining witness stated the defendant arrived at the residence, and while complaining witness one was trying to calm down the situation, the defendant struck complaining witness one in the face, and in the process of breaking the fight, the second complaining witness was struck on the shoulder, causing pain.
But we only have the assault on the gentleman, correct?
But the assault's only on the, I'm sorry?
The gentleman.
I believe so,
You
yeah.
only got one count.
Yes, Your Honor.
Okay. Ms. Blewett, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you, there's a protective order that has been issued in this case. You need to get to know it. If you do something to violate the protective order, the state can and probably will file additional charges against you. Do you understand?
Yes, sir.
I'm ordering you not to have any contact with this person and not to be in possession of any weapons. If you violate this, I will revoke the bond, put you in jail. No more PR bonds for you, man. Do you have the ability to hire a lawyer?
Court appointed lawyer, court appointed.
Do you have the ability to hire a lawyer? Okay, I can have you fill out an application. I'll take a look to see if you qualify. I need to know everything about you, how much money you have in the bank, how much money you work, and I'll take a look if you qualify. I'll have you sign a receipt. Victoria, Deputy Miranda going to give an application, and I'll have you take your seat in the jury box. Do not leave until you sign our bond condition. Can you file no contact, no weapons, please?
Yes, Your Honor. So no contact, no weapons.
Yeah. Good morning, Mr. Delaney. Sir, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Thank you, Judge. On March 31st, 2025, in Harris County, Texas, a law enforcement officer responded to a trespass at a gas station known for being a drug trafficking hotspot. Law enforcement officers witnessed surveillance footage of the defendant making multiple hand-to-hand transactions and throw something in his vehicle when the law enforcement officers originally approached the gas station. The law enforcement officers detained the defendant and approached the vehicle and witnessed 2 sacks of marijuana on the passenger floorboard area in plain view. A probable cause search was carried out, and the officers identified the 2 sacks on the passenger floorboard as marijuana. The total weight of marijuana was 76.37 grams.
Mr. Delaney, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you not to go back to this gas station. Do you understand? I'm also ordering you now not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. Do you understand?
Good.
No more slinging. Do you understand? What do you do with yourself these days? Do you have a full-time job?
I'm doing application right now. I have an interview tomorrow.
Good. I'm bringing you back in 2 weeks, and I want to see that you have a full-time job. Do you understand? If you come back and you've done nothing, it's not going to go well. And I'm telling you, I'm going to drug test you within the next 50 days. If I find that you continue to use, it's not going to go well for you. You understand? All right. Did you want to apply for a court-appointed lawyer? Okay, Deputy Miranda's going to give you an application. I'll have you sign a receipt in Victoria. You will then meet with Fleischer for your bond conditions. I'm also ordering you not to be in possession of weapons as well. Do you understand? Okay, come on. What, you said 15?
15 is GD.
What's your?
15 is GD.
Yeah, but hey, 15?
Oh, I'm sorry. Phillips is on page 15.
Yeah, okay. You're, Mr. Phillips, you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Judge, on September 1st, 2023, a law enforcement officer responded to failure to stop and give information call in Harris County, Texas. The law enforcement officer made contact with the complaining witness, who stated that she was pulling into a parking lot of a corner food store and observed the defendant's vehicle reverse into her direction quickly. The vehicle then rammed into the rear driver's side of the complaining witness's motor vehicle. The defendant's vehicle then quickly shifted into drive and fled the parking lot. The complaining witness took a photo of the rear of the defendant's motor vehicle after the accident and provided the license plate to the law enforcement officer. Law enforcement officer found the motor vehicle registered to an address less than a mile away and traveled to that address and made contact with the defendant. The defendant stated he was at the food store with bursting out of the parking lot and struck the complaining witness. The defendant stated he fled without providing information because he did not have a driver's license. The defendant was identified with his Texas ID.
So, can you run his license, please, just to make sure?
Yeah, Your Honor, I'm just not showing a driver's license numbers, so I'm not sure if he is part of the license since then, but we don't have it in our system.
If you do not have a license, do not drive. I don't care what's going on in your life. I don't care that you have to go to work. I don't care that a baby needs to go to the hospital. I don't care there's a burning building and you need to save 50 kittens. If you don't have a license and liability insurance, do not drive. You will be signing an affidavit with me today. This is the promise that you're going to make, that you're not going to drive. You cannot justify getting into a car for any reason. And if you do, you can be facing an additional 6 months in jail on a contempt charge. Every time you drive, it's an offense in and of itself. Do you understand? What do you do with yourself these days, Mr. Phillips?
I work and take care of my little sisters. My dad recently passed away.
You have a full-time job?
Yes, sir.
Did you graduate from high school?
Yes, sir.
Okay. Did you want to apply for an appointed lawyer?
Yes, sir.
Okay. I need you to qualify. I need you to fill out an application. I'll take a look to see if you qualify. I need to know everything about you. Do not drive, Mr. Phillips. If you want to drive, go get a license, get insurance, show me that you have these, and then we can talk. But until that point, don't do it. There's going to be HE double hockey sticks to pay if you do. You understand? All right, come on.
Robert Shelby and the holdover, you wanted to, Bill Strategy had to leave, you wanted to.
You mind? Yeah, please. So I'd like to do the PC. I just want to know, because it's a DWI second, there's also an evading. If you could just give me a brief rendition of what happened, please.
Yes, sure.
When he comes out.
Yes, sure.
Morning, Mr. Shelby.
Morning.
So your lawyer was here before I got here, and he had to leave to go to a funeral. So I wasn't able at that time to do conditions, but I want to put bond conditions on you because you now stand charged with a driving while intoxicated, second offense. You're also charged with evading arrest in a motor vehicle, which that one is a third-degree felony. You're facing up to a minimum of 2 years, a maximum of 10 years in the Texas in the TDCJ. So can you please give us, you have the right to remain silent. Anything you say can or will be used against you, sir.
Good judge. On April 3rd, 2025, in Harris County, Texas, an officer observed the defendant's vehicle traveling 117 miles an hour using a rear antenna radar. The officer observed the defendant weaved between vehicles in an unsafe manner, and a traffic stop was attempted. The defendant passed an available exit with no indication of stopping and ran a red light. After a 20-minute chase, officers stopped the defendant's vehicle using a pit maneuver. The officers moved the scene to a parking lot, and upon contact with the defendant, the officer noticed glossy eyes and bloodshot eyes with an odor of alcoholic beverage. The defendant was identified by his Texas driver's license, and standardized field sobriety tests were conducted. The officers witnessed 4 to 6 clues on the HGN, failed to keep balance on the walk and turn, and the defendant refused the one-leg stand. The officer is a drug recognition expert and observed signs of drug intoxication. The IC was read, the defendant refused, a blood warrant was executed, and blood was collected.
Can you run his license, please? See his license.
He doesn't know. So,
At 117 miles an hour, Mr. Shelby, I'm now taking away your privilege to drive. I'm appointing you, Mr. Pruitt, here in the interest of justice now because your lawyer's gone to a funeral. But I'm putting these bond conditions on you now. And I want you to know that I will do everything in my power to protect my community at all costs. Do you understand?
Yes.
You are not allowed to drive.
Yes, sir.
At all. You will be signing an affidavit. This is a promise that you're going to make to me that you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a monitor on your ankle so I know that you're not consuming. You will be tested for drugs and alcohol. If I find that you're using, likewise, I will invoke your bond and put you in jail. If you have a problem with drugs or alcohol, now is the time to address it. Because if you don't, and I see that it becomes a problem while you're on bond, I will address it for you, and I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I am now sending notice to DPS that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Every officer in this state will know that if you're pulled over and you don't have an interlock on whatever car you're driving, they will arrest you and put you in jail. And that is a violation of your bond condition here. Do you understand?
Yes.
You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. As it stands now, I'm taking away your privilege to drive, so you're not allowed to drive. You will get a device on your ankle so that we know that you're not consuming.
Yes, sir. So he's not required to get the interlock unless you rescind that order for him not to drive?
Correct. You will get a STRAM device within 3 days. Within 3 days of your release, you will be required to get a STRAM device. And if you fail to do it, then your bond is going to be revoked. As it stands now, you haven't made bond on the DWI in your felony case. That's why you're still being held now.
That's a SCRAM device.
It's a device that goes on your ankle so that we detect through perspiration whether you consume it. All right. I just wanted to bring you out to give you notice of the condition that we're placing forth on you now. All right? Okay. All right. So we need him to sign this and then sign with Fleischer and then.
Thank you.